Welcome, Nick. Hi. Let us just kick off with the most obvious question. Can you point out to the main highlights of the directive, especially for people that don't know it in detail?
Sure, and thank you very much for the invitation to come speak here today virtually. So yes, as you have pointed out, the European Union has adopted a directive on whistleblowing protection that indeed has to be transposed by the 27 member states by the end of next year. It's something that Transparency International has pushed for a number of different years, and I have to say that what has been adopted is quite comprehensive in nature and quite progressive. And it will mean that a number of national laws will have to be introduced or adapted accordingly. First, it offers protections to employees in traditional contracts, but also non-traditional contracts in both the public and private sectors. It introduces a number of protections that it didn't exist before in a lot of member states, with a lot of provisions to ensure that the whistleblowers are not only protected if they disclose wrongdoing, but also to give them the confidence that if they report, that those protections will be generated by their employer, but if not, there will be sanctions introduced if, say, retaliation is brought about to the different employees. I think that there was a number of different elements that I found to be most important in this, not least that the European Commission, to their best of their ability, tried to make the material scope of this directive as expansive as possible within the limits of course, the competences of the Union. So there is a number of different sectors that will be affected by this. Protections will be offered for wrongdoing that's reported in the context of public procurement, consumer safety, nuclear safety, the protection of EU financial interests, so budgets. It's very expansive. And so there will most likely be a great track of sectors that will be affording these protections to their employees going forward. I think that one of the most important elements of the directive, and perhaps one of the strongest battles that civil society and trade unions undertook to ensure that it was adopted, was the issue of reporting channels. There are three options for reporting channels under the directive. There is an internal option, where you report internally in your organization the wrongdoing and are afforded the protections. The second option would be to report externally, and externally in the context of the directive really refers to relevant law enforcement or regulatory agencies. The third option is also going public, and this is only under certain conditions, and when they've been met, the whistleblower can be afforded protections if they report to the media. For us, it was always important because there was in the original Commission proposal, and a number of member states felt that there should be an internal first principle. Of course, as an anti-corruption agency, we never believed that a whistleblower wouldn't be protected, or even worse, face potential sanctions if they didn't report, if they reported first to law enforcement agencies. We always felt that the first two options should be on equal footing, and the whistleblower, depending on his or her circumstances, could either report internally and externally in the first instance. Ultimately, we were able to achieve that, and I think it's probably one of the most fundamentally important structural aspects of the directive. Of course, there are a number of different elements as well that we are quite pleased with, from confidentiality requirements and also sanctions related to if the employer, retaliates against the person disclosing. I mean, there are a number of different elements. on where we think that the directive could be improved. But I think for us in the EU office, looking at this from a horizontal perspective and how this applies to the 27 different member states' regulatory frameworks, the most important element that needs to be addressed in the transposition process is the issue of material scope. Again, as I mentioned previously, despite the Commission's best efforts, there are still limitations that must be appreciated because of simply the competences of the Union and the treaties. And so for us, our main focus in the transposition exercise is to ensure that member state governments use this opportunity to incorporate national laws into the transposition process. And this is important for, I suspect, I would argue 2 reasons. One is if you don't do that, you are going to have a sort of a 2-tier framework for whistleblowing. This is going to not afford the legal clarity that is necessary for people to report wrongdoing and feel protected, or have the confidence that they will be protected. I think that this is important, obviously, for the whistleblower, because one of the main goals of having any effective blowing legislation is that, again, that he or she, if they disclose wrongdoing, feels comfortable that they will be protected. But I actually think that this legal clarity is equally as important to employers. You know, employers must feel that they are appreciative of the rights and obligations that they will face under the regulation if that person's reporting. And if they're reporting only on EU matters, it's going to become much more complicated for both parties, the employee and the employer. And so I think that for us is the most important element. And of course, this is also important to the Commission. If you recall, this was an issue that was already identified as a potential problem if this was adopted. And when the Commission proposed the original directive, they also unusually issued a corresponding communique, which essentially asked, if this was adopted, the member states do incorporate national laws. This is unusual, of course, because this is gold plating, and oftentimes the Commission doesn't try and inspire member states to do this. But in this instance, I think everyone recognizes the importance of ensuring that national law is also transposed along with the EU elements of the directive.
Could you perhaps give a brief overview of the transposition process now? Most of the countries are still at the beginning, but could you go through the transposition process
Sure.
on the EU level?
Sure. I mean, yep. I mean, one of the motivators of trying to address the issue of whistleblowing protection from the EU was the fact that in the member states, the protections varied greatly depending on which country you're in. Everywhere from, yes, there was a public sector protection or only private sector, to some member states that didn't have any protections whatsoever. And so one of the main motivators of addressing this issue from an EU-wide perspective was that it needed to be done horizontally. So the transposition process, to some degree, will vary greatly depending on where the laws are in development or adoption phase in the member states. So for countries like France, who have recently adopted whistleblowing protection, the transposition process will probably be not as significant in nature as some member states that don't have anything on the books as far as national laws. Each of the member states will have to either introduce or amend their national laws according to the articles in the directive, as you said, before the end of next year. This work has begun in some member states from a ministerial technical perspective, but as far as I am aware, there haven't been any significant developments on draft laws as of yet. But we expect that this work to be undertaken shortly, because it will take some time, particularly in some member states that don't have any regulations in place, to have these laws adopted before the end of the transposition period. The Commission is actually taking additional steps that sometimes they don't undertake when transposing a directive, insofar as they've established an expert group. This expert group has met several times. It's comprised of the relevant ministerial representatives from the member states involved in the transposition. There's a lot justice ministries involved, but there's also other ministries depending on the provisions that need to be adopted in the rest of the directive. It's meant as a way in which the Commission can offer guidance, address questions, and also serve among the different member states as a sort of an information sharing platform on some of the concerns that they're experiencing, or some of the issues that they're quite not sure how to adapt to national legislation.
You mentioned it briefly, but do you reckon that member states that do not have any legislation in place right now will have an easier or a more difficult job to transpose the directive? I mean, in some ways, I mean,
it's a good question.
Yeah, I mean,
exactly. No, I mean, one might argue that they have an easier job because they have a blank template to work with. To a certain extent, they could almost transpose it verbatim based on the existing directive's text. So yes, I think that actually the ones who don't have laws in place might find it easier. I know that some of the largest resistance in the context of the negotiations in the Council came from member states that already had developed laws in place who didn't want to adapt them too much. Yeah, so many of their member states' positions was, we will agree with the articles of the directive that exactly mirror our own national legislation, and we will oppose any articles that deviate from existing national legislation. And France is probably the most obvious example of that, simply because they have a very developed framework that was recently adopted, and they simply didn't want to revisit it.
From the institutional point of view, how do you reckon that the directive be put into practice effectively through institutions? I mean, this is something that we are discussing quite heavily in Slovenia as well.
Yeah, no, I mean, I think it will, again, much like the transposition process, vary between member states. And I think the directive speaks to this insofar as they don't have, institutional structural obligations per se. I mean, I think that it will be up to the member state to decide how to delegate the responsibilities of this, say, among central authorities or regional authorities, or having a central body or not, will be, again, up to, I think, the national contexts. I think that there'll have to be, perhaps, if the previous state of play is any indication, there will be, I think, a bit more burden on the public institutions, not only to adapt with having to deal with the implementation of this, but also to create their own structures of whistleblowing and disclosure mechanisms. Because actually, you'll find that the private sector is a bit more advanced universally on this, not least because, at least from the EU perspective, whistleblowing has been addressed at an EU level, but on a sectoral basis, mostly around, say, finance and banking institutions. Yeah? And also, having spoken to a number of business associations through the negotiations in Brussels, they, again, have a lot of frameworks already in place. They just don't call them whistleblowing frameworks. They call them compliance frameworks. Because, again, the private sector long ago realized that it is beneficial to them as an organization to have these risk management frameworks in place. And although they call it perhaps compliance or risk management, what you're really talking about is whistleblowing and disclosure mechanisms. I talked to one business association who had developed an algorithm that would be able to anticipate risks in the company based on anonymous tips through an application that they gave to employees. So an app on their phone. So again, I mean, I think if you compare the private and public sectors on this, I just don't think it will be as burdensome, at least from the business associations that I spoke to implement this, because to a large degree, if they have a developed risk management system in place, it will incorporate whistleblowing or disclosure in them already. again, perhaps by a different name. And so I think, again, as I said, perhaps the greater burden will fall on the public institutions to develop these.